Hello there, law seekers. Today we look at the new immigration reality. First, the 2025 DHS Final Rule, which gives USCIS officers enforcement powers. This rule is now in effect, so enforcement is not restricted to ICE anymore. It affects nearly every immigrant in the United States. It also impacts those planning to come. The changes are significant. They are complex. They are urgent. If you are a green card holder, if you are a visa holder, if you have any connection to the U.S. immigration system, you must understand what this rule means for you and your family. The landscape has shifted dramatically, and inaction is a risk you cannot afford to take. The time to learn and prepare is now, before this new rule creates irreversible problems for your future. This is not comprehensive reform. It is a targeted rule focused on enforcement. USCIS can now arrest, carry out searches, issue warrants, investigate and prosecute immigration offenses without involving ICE. Then there is the One Big Beautiful Bill Act. It is about funding. It is about penalties. The law allocates an unprecedented $170 billion toward enforcement. That funding expands capacity to detain, to process cases, and to remove non-citizens. It introduces new fees, making immigration more expensive for many applicants. Importantly, the goal is to deport 1 million people per year. Now you know, that is where things stand. Then there is the 2025 DUI immigration bill, threatening key changes for green card and visa holders. For decades, a green card has been seen as a symbol of stability and a secure step toward U.S. citizenship. The new DUI bill challenges this perception directly. The primary change for non-citizen, including lawful permanent residents, is an increased level of scrutiny and a lower threshold for what constitutes a deportable offense. Your status is now more tenuous than ever before, because driving while intoxicated or impaired will be grounds for deportation or inadmissibility. In this time, simple interactions with law enforcement or mistakes on administrative paperwork carry far greater weight. The protections you thought you had as a permanent resident have been significantly weakened, requiring a new level of diligence and caution in your daily life. One of the most significant changes involves the concept of inadmissibility. This legal term determines who can be denied entry into the U.S. or denied a green card. The DUI bill seeks to expand the list of reasons a green card holder can be deemed deportable, even after having lived in the country for years. This is especially critical when you travel abroad. Upon returning to the U.S., you could be subjected to stricter screening. A DUI issue that may not have been a problem in the past could now prevent you from re-entering the country and reuniting with your family. This law is not yet in effect. It is passed by the House, but now needs to be passed in the Senate and signed by the President. Furthermore, there is a new rule introducing new complexities for employment authorization. DHS has ended the practice of automatic extension of employment authorization for persons filing renewal applications of their EAD effective October 30, 2025. USCIS urges aliens to apply up to 180 days before their EAD expires in order to prevent delays. Also remember the new naturalization rules effective since October 20, 2025. Interviews may become more rigorous, with the focus on assessing good moral character, contribution to the society, and deeper background checks. Government officers will have greater authority to re-examine your entire immigration history, looking for any past inconsistencies or issues that might now be grounds for denial or even removal proceedings. There is a more difficult civics test, with increased questions requiring a higher passing score than before. The burden of proof to demonstrate your continued eligibility for permanent residence has grown heavier. Your physical presence in the United States has also become more critical. Starting December 26, 2025, all non-citizens will be photographed when they exit the USA in order to keep better records of your movements. While green card holders have always been advised against long absences from the country, the new approach of greater scrutiny may see more immigration officers exercising their discretion to determine that you have abandoned your residence. Trips that were once considered acceptable might now raise red flags. This reality requires meticulous record-keeping of your ties to the U.S., such as property ownership, employment, family presence, and avoiding long stays overseas without a re-entry permit. There is now a sweeping overhaul of enforcement and financial obligations, not a minor update. ICE's budget is significantly increased to expand detention to over 116,000 beds. This signals an intention to detain more people navigating the system. New fees include a $1,000 charge for some humanitarian parole requests. These changes create a more formidable and costly system, including for asylum seekers. The stated goal is to strengthen national security and shore up system integrity. But the practical effects will hit the immigration landscape hard. Families may face new financial barriers. Individuals may be vulnerable to deportation for actions once seen as minor. Understanding the changing landscape is step one to protecting yourself. The 308% increase in funding for ICE detention beds is a stark indicator of the government's new posture, a staggering $14 billion per year. This means more individuals are likely to be detained, likely separating families and making it more difficult to access legal counsel. H-1B visas and L-1 visas are categories that may experience increased scrutiny during visa renewals and when entering the country. The massive increase in enforcement funding means that worksite investigations are likely to become even more common, putting both employees and their employers under a microscope. Any discrepancy in paperwork or violation of visa terms could lead to swift revocation and removal. Students on F-1 visas, visitors on B-1, B-2 visas are not immune to these changes. The current immigration landscape is accompanied by a revised fee structure that increases the cost of applying for and maintaining status. Furthermore, border officers have been given broader authority to question the intent of visitors. They will be looking more closely for any sign that a student might be violating the terms of their stay. If you are a green card holder or have another non-citizen status inside the United States, remain calm and law-abiding. Do not panic. Begin by gathering and organizing your important immigration documents: green card, passport, social security card, USCIS notices. Check the expiration date on your green card. If it expires within the next year, begin renewal immediately. Delays are common. Don't be caught with an expired card under this new legal climate. A licensed attorney gives accurate counsel for your unique history. A consultation can identify risks and create a strategy, like applying for citizenship sooner or other defensive measures. Finally, if eligible, consider applying for U.S. citizenship now. Naturalization is the best protection against deportation. While the process may be stricter now, it's the most secure long-term solution. An attorney can help file forms correctly and prep you for the interview and the exam. This is the ultimate step to secure your place in the U.S. permanently. For a green card holder, an arrest is no longer just an arrest. It is an immediate threat to your immigration status. If you are charged with any crime, no matter how minor it seems, you must consult with an immigration attorney immediately, in addition to a criminal defense lawyer. Pleading guilty to what seems like a small offense to make a problem go away could be an irreversible error that triggers deportation proceedings down the line. So, be careful and get legal help right away if anything happens. For those who are currently outside the United States but hold a green card or are planning to travel to the U.S., the new reality requires a higher level of preparation and vigilance. Before you travel, you must double-check the rules and requirements for entry. The new stricter approach means that U.S. Customs and Border Protection officers at airports and land borders will be applying stricter standards. Be prepared for more detailed questioning about the purpose of your trip, your ties to your home country, and your history. Ensure you have all necessary documentation readily available and that it is all current. If you are a lawful permanent resident who has been abroad, be particularly careful about the length of your absence. Immigration officers now have more leeway to conclude that you have abandoned your residency if you have been away for an extended period. If you must be outside the U.S. for a long time, it is essential to maintain strong ties to the country, such as filing U.S. taxes, maintaining a bank account, and keeping a U.S. address. It may also be wise to apply for a re-entry permit before you depart. Consult an attorney before any long trip to understand the risks. The financial aspects of your immigration applications also require planning. If you are applying for a visa or for a special permission to enter, such as humanitarian parole, you must be prepared for higher fees. If you liked this content, then give up a like and share and subscribe for more. See you next time.